Hello, this is Soumya Verma Sundar, and I have come up here with my next lecture on Section 5 and 6 of Indian Evidence Act 1872. Section 5 states that evidence of facts in issue and relevant facts. Evidence may be given in a suit or proceeding of existence or non existence of every fact in issue and of every relevant fact and of no others. So, section 5 states that evidence can be given of only fact in issue and relevant facts. We will go for the illustration here, where A is tried for murder of B by beating him with a club with the intention of causing his death. At A's trial, these facts are in issue. A is beating B with the club. A is causing B's death by such beating. A's intention is to cause B's death. So these three are fact in issue in the above illustration. Doctrine of res gesti. We all know about the hearsay evidence, that it is a kind of evidence where we hear some information from other person and perceive it as a true information, but it is a hearsay information, it is a hearsay evidence, and we cannot take a hearsay evidence as a form of evidence under Indian Evidence Act, but there are certain exceptions under it. For example, section 6, which is also called the doctrine of res gesti. Whenever a transaction as a contract or a crime is a fact in issue, then evidence can be given of every fact which forms part of same transaction. The facts which surround the happening of an event are its res gesti. There is a important case law on it, Ratan versus the Queen, 1971. A man was charged with the murder of his wife. He defended himself in the court saying shot that the shot went off accidentally. However, there was evidence to show that the deceased wife contacted the telephone operator and said, "Get me the police, please." But before the operator could connect the call to the police, the lady who spoke in distress gave her address, and then the call ended suddenly. Thereafter, police went to the address so given and found the dead body of a woman, that is, the wife of the accused. Lord Wilberforce, delivering the judgment, explained that the act of the deceased of calling telephone operator and the words said by her on the call are relevant facts, as they form the part of same transaction which is in the issue before the court. And on the basis of these facts, the accused was convicted for murder, as no victim of an accident can even think of calling the police and ask for help before the happening. Her call in distress clearly showed that the shooting in question was intentional rather than being accidental. Section 6 of Evidence Act states that facts which, though not in issue, are so connected with the fact in issue as to form the part of same transaction are relevant, whether they occurred at the same time and place or at different times and place. Illustration is given as A is accused of murder of B by beating him. Whatever was said or done by A or B or the bystander said beating, or so shortly after it as to form part of same transaction, is a relevant fact. Principles of section 6 can be seen as that wherever a transaction such as a contract or a crime is a fact in issue, then evidence can be given of every fact which forms the part of same transaction. Transaction refers to a series of acts so connected together are capable of being called by a single name. For example, contract, crime, etc. A transaction may be described as a physical act or series of connected physical acts together with the words accompanying such act or acts. where the transaction consists of different acts in order that the chain of such acts may constitute the same transaction. They must be connected together by the proximity of time, proximity or unity of place, continuity of action, or community of purpose or design. So, the principle of the section is that whenever a transaction, such as a contract or a crime, is a fact in issue, then evidence can be given of every fact which forms the part of same transaction. It is the gist. In the next lecture, we will study section 7 and section 8 of Evidence Act. Thank you.